Hello everyone, this is Tony Blackwood, Senior Counsel with Husch Blackwell and leader of our immigration group. We're excited to be talking with you today about the new era in immigration-related worksite enforcement actions. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We really appreciate audience participation and we encourage you to submit questions. There's also an icon to assist with your viewing preferences. Please note that you can expand your slide area by clicking on the Maximize icon on the top right side right of the slide area or by dragging the bottom right corner of the slide. If you have any technical difficulty, please click on the Help icon. It has a question mark and it provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is Kelly Stout. Kelly focuses her practice on business immigration law, representing employers across various industries to develop long-term immigration planning for foreign national employees, and she also works with employers for compliance issues, such as we're going to discuss today. Today we're going to talk about the new era in immigration-related worksite enforcement actions. And we're going to cover three sort of main areas. First, we're going to talk about the kind of worksite enforcement actions and the best ways to handle them, best practices. We're also going to talk about more focused worksite inquiries. And finally, we're going to talk about how to prevent, when possible, those workplace enforcement actions to begin with. So turning our attention to the types of worksite enforcement actions, they are carried out primarily by three agencies. The first is the Immigration and Customs Enforcement Agency, otherwise known as ICE. This is the main law enforcement agency for immigration matters, and they do all kinds of investigations and enforcement actions. They are the agencies that show up to do your I-9 audits. Sometimes they come to your workplace to look for and arrest and take away a particular employee. We'll talk about that in more detail in a bit. Sometimes they'll come looking for documents and other evidentiary materials for an investigation that they're conducting. They may occasionally come to your work site to carry out a raid and take away numerous employees. Most of the time, an employer will have advance notice about a raid, and they are occurring much less often than they used to. The workplace raid was a very favorite tool of the George Bush administration, but it has become almost invisible since the Obama administration. And as we'll discuss sort of off and on today, the types of enforcement actions that we see do vary over time with the administration in place. So worksite raids were common before, not so much these days, but they still occur occasionally in the right circumstances. And USCIS ICE may conduct employer investigations and prosecutions. They may have an employer in their sites that they think is breaking the rules about employing unauthorized workers, or maybe actively recruiting, harboring, trafficking in unauthorized workers. So ICE is the agency that conducts those investigations and prosecutions. USCIS has a hand in worksite enforcement. They are responsible for investigating the employer compliance with the H-1B program and the L-1 program. The H-1B is the type of visa, as most of you probably know, that is available to individuals who are basically degreed individuals coming in to perform professional services. And the L-1 is the employee whom employers may bring in from a related entity overseas. Both of those programs have received a good bit of congressional attention in the last couple of years and are in the sights of the current administration, so we expect to see these investigations to increase. And USCIS does fraud investigations. Not on your slide, but also a part of this investigation and worksite enforcement program is the Department of Labor. Theirs are less specifically immigration focused, but their investigations through the OFCCP and the Wage and Hour Division frequently land on ICE's desk when they see something that raises their attention. So let's have our first poll question today. Has your organization ever been visited by ICE or the USCIS Fraud Detection and National Security Directorate, otherwise known as FDNS? Yes? No? We have 100% answers here, and 80% of us, nearly 90% of us, have never been visited. So that's good news to most of you, but to those of you who have, you know it's not a fun exercise. So let's talk about the worksite enforcement actions of ICE. This is the heavy hitter in this world. The role of ICE, the Immigration and Customs Enforcement Agency, is to enforce all the immigration laws within the U.S. It also enforces other laws. The name of it is Immigration and Customs, and so this is also the agency that seizes contraband and enforces all the customs laws in the United States. So it's a very big, very powerful, and very busy agency. Immigration is only half of its portfolio. In the immigration world, they are responsible for detaining, prosecuting, and removing people who are improperly here for whatever reason. They may have overstayed their visa, they may have come in without authorization to begin with. The current administration has announced an intent to hire 10,000 new ICE agents. There has been trouble in getting these people on board, and there is not enough money to pay for them right now, but it does reflect the intent and the emphasis of this current administration on enforcement. One of the main things that we see them doing is conducting Form I-9 audits. The I-9 form that tells every employer about every employee as to whether they are authorized to be in the workplace or not. They audit your forms and they levy penalties and fines against employers who don't comply with the spirit and the letter of the law. ICE also administers the F1 and J1 programs. The F1 is the international student who may be admitted into secondary and post-secondary educational institutions in the U.S., and the J1 is the visa that allows people to come in for a wide variety of programs through the exchange visitor program. ICE does perform worksite enforcement actions, which we'll talk about in more detail in a few minutes, on a random tip-generated and industry-focused basis. I'm going to cover that in more detail So let's just skip to the next slide. The triggers for a worksite enforcement by ICE are many, and we probably actually don't know all of them. But here are a few of them that continue to pop up that we do know about. Sometimes a foreign national employee of an organization will commit a crime. And although ICE is not responsible for prosecuting them for the crime, of course, that's the purview of the jurisdiction in which the crime is committed, but they are responsible for bringing them before the immigration court. Sometimes a criminal offense will make them deportable, removable, and that's the responsibility of ICE. So they may come pick them up at the workplace. Workplace is an obvious place to seek and employ an individual because it's predictable. They're pretty sure that they're going to be there at one time or another. So that is a common occurrence. A person who is before the immigration court for any number of reasons may fail to appear. And if they do, ICE is the agency that comes looking for them. And again, they'll look for them at work. Sometimes they'll show up at the workplace because they have received information from employees or someone outside of the workplace that the employer has an unauthorized worker. Sometimes it will be an individual named, and they'll be looking for somebody in particular, and sometimes it will be an investigation that's broader. Sometimes those investigations may be so serious in the minds of the ICE investigators that they are conducting covert investigations. These are the situations where when it all becomes known, it turns out that there have been employees in the workplace wearing wires, broadcasting technology, meeting with ICE outside the workplace, and if that's going on, if you find out that that's a very serious kind of investigation. Sometimes ICE will show up because of results out of E-Verify. They use E-Verify for data mining, and if they see troubling patterns in the documentation of people in a particular workplace, they'll come look at it. And then they look at targeted industries. It used to be industries like restaurants and construction where there were lots of low-skill employees. It is now anticipated with the emphasis that has become obvious through the statements of administration currently that they may be looking at staffing companies that hire out their foreign national workers to other companies and IT companies. And then finally, they may get information from other agencies that are in your workplace. The Department of Labor is a prime example. OFCCP and the Wage and Hour people will nearly always look at your I-9s, and if they see something that comes to their attention, they'll refer it to ICE as well. The best practices in handling an ICE enforcement, of course, is always call your lawyer when you figure out that that's going to happen. As soon as you get word that ICE is going to be there or when they show up, call your lawyer. Before that happens, though, you should think about who in your organization would be the best person to delegate the responsibility of dealing with ICE when they're on premises. Get somebody who thinks logically, who has a cool head, who can be diplomatic but firm, stand up for your interests, but not offend the officer, because we have really very little leverage in the early part of an investigation. So make that designation, and then work out procedures to guide people who are the sort of your first responders, your receptionist, the manager who's likely to encounter the agent when they come in the door. Make a plan. In other words, don't be unprepared for this to occur. When the officer gets there, always get their business card. Never leave them alone on the premises. Accompany them everywhere. And don't let them go into private places. We'll talk about that later. I-9 audits are a particular kind of investigation, and we've talked about these before. I'm just going to briefly summarize the way this occurs. The employer usually receives a notice of, always receives a notice of inspection. There's a little clip of it on this page. You have 3 business days to produce the required documents after you receive this notice. You may be able to negotiate a little bit more time if you have a good reason and if you have a friendly auditor, which is usually the case. But that request will always include your I-9s and the applicable period of payroll reporting. Sometimes they're going to want business documents like your governing articles or your operating agreement, business licenses, something like that, just to give them an idea of how your business is structured, who's in charge, who owns it, and so forth. If you have electronic I-9s, they're always going to want access to the software, and they're going to want that software to perform the kind of functions that are required in the regulations for electronic I-9s, so be sure that you know those. Form I-9 audits will result in a number of different things. First, you may get a green light, everything's great. You would be among a tiny percentage of employers if that happens to you. But if it does, congratulations. More likely is that you may receive a warning notice. They're going to let the small things that they found go, but they expect you to correct them, and you can expect them to be back if they issue you a warning notice and go away. If they don't do that, they may give you a notice of discrepancies. This gives you a little bit of time to correct the information about or to investigate the information about the employees that they find that do not match the information in their records. And you can submit that information to them. If there are remaining doubts about individual employees, then you'll get a notice of suspect documents, which gives you one more chance to go to that employee and clear that confusion up. And if you can't do it, and the employee can't do it, ICE will expect you to terminate their employment at that point. They may give you a notice of technical or procedural failures. If they're technical, they'll give you 10 days to correct them. If they are substantive, they will issue a notice of intent to fine. If you get a notice of intent to fine, it's always the beginning of a negotiation. That's when you really are going to be relying on your attorney to help you out. Let's go to another poll question. Does your organization conduct regular internal Form I-9 audits apart from a government investigation?
We're asking this question for a reason. We're going to talk about best practices next. And so this is one of our suggestions as a best practice to protect yourself in the event of an I-9 audit. And it looks like we're a little bit split. A lot of you are doing an audit every once in a while. Some you're just not doing them at all. That's most of the organizations I encounter. Either just kind of do an internal audit when it's necessary or when you think about it. But we're going to talk about best practices and talk about the importance of regularly scheduling these internal I-9 audits, making sure you're continually looking at them. If you're a larger organization where there's a lot of turnover, schedule those audits more frequently than if you're a smaller organization where there might not be a lot of turnover or have a little bit more oversight over the I-9 process. But if you're an organization where you've got managers on the field and you're not necessarily keeping watch over every single I-9 form that you do because it's just unrealistic or impossible almost, you might want to be thinking about regularly scheduling those internal I-9 audits. And even just, looking at a few I-9s here and there, doing a random sample of your I-9s is also a way to do it if you don't want to go through, say 1,000 I-9s every year. That also purge those expired forms. Forms expire 1 year after the employee is terminated, or 3 years after their start date, whichever is longer. So make yourself a schedule for when those I-9s should be thrown out or discarded. and make sure that they are out of your I-9 file. But just some other best practices in the event that you find yourself or your organization finds itself within an I-9 audit is to use those 3 days. Use those 3 days that you get after you receive a notice of the audit or a notice of inspection. You'll have 3 days to produce those documents and use those to make corrections where possible. Make copies of any documents you produce to ICE. It seems like an obvious thing, but so often you get so caught up in the shuffle of everything that you just forget to if they ask for more documents such as a payroll records or other documents, that you just forget to make copies of what you submitted to ICE. So make sure to do that.
And always, always copy the I-9s that you send to ICE.
Yes. Yes. And, somebody's asking, too, as a best practice, should you be keeping those I-9s separate from other files and from the employee personnel file? And yes, you should. Make sure that those I-9s are sort of set apart from the employee personnel file because in the event that you have an ICE auditor on site, you just want to be able to pull a file, here's the I-9s, and not have to make those personnel files sort of opened up to the ICE auditor, or to have to go through all of the personnel files, even from a more practical standpoint. And communicate with the ICE officer regarding deficiencies. This is where experienced immigration counsel can really come into play. If you have an immigration attorney or experienced counsel who knows what they can ask from the ICE officer, how to negotiate with the ICE officer, has been through the process before, they can be a great sort of resource and a representative for you in negotiating and communicating with that ICE officer. But normally they are open to talking. They'll answer your phone calls or emails in this sort of process, which is drastically different from any other immigration process you'll ever go through. But in this particular process, the ICE officers are usually willing to talk to you. And then address any deficiencies listed by the ICE in those notices that Tony talked about as soon as possible. A lot of them will have a deadline on them, such as 10 days. Make sure you're making note of those deadlines and taking care of them as soon as possible. Sometimes ICE comes and requests documents. And Tony touched on this before, and now we're going to dive a little bit deeper into it. In most cases, ICE will present a subpoena or search warrant for these kinds of documents, and they should present it. They might be looking for employment records. They might be looking for other records. I know that we have a lot of colleges and universities in this webinar, and some healthcare organizations, sometimes they're looking for student records or patient records. And I'm not going to dive into that too deeply, but just to say that for student records and patient records, obviously there's some other laws that come into play about what you can and can't disclose, and a lot of times the federal government might, an ICE officer might trump that with a subpoena or search warrant, but certainly FERPA and HIPAA are two considerations that I'm not going to talk about, but certainly come into play with students and with patients. But if they do come, the best thing you can do is to notify an experienced attorney. They can look at the subpoena search warrant if there's time to do that, and let you know sort of the bounds of the authority that the ICE officer has. And in most cases, you're going to have to turn over the documents. But getting an experienced attorney in on site to sort of address the situation, analyze the potential for liability, and minimize that liability for your organization is incredibly important. But when you are facing with that ICE officer who's handing you that subpoena or search warrant, obtain a copy of it. The first thing you need to do is make sure you have a copy of it. You're entitled to that. And then carefully review that subpoena or search warrant for the exact documents requested. What is it exactly requesting? You do not want to provide more information than that subpoena or search warrant asks for. Make a copy of those documents produced as well. If the officer has the authority to search, computer files or file cabinets or something else, accompany them, make note of what they're doing, where they're searching, and then of course make a copy of the documents that are presented. Somebody asked, are the ICE officers, when they do come on site, well-trained? Can you expect them to be well-trained? And I think in any sort of situations like this, it's kind of hard to say what you can and can't expect. There are some ICE officers who will show up without a warrant and just expect you to hand over, whether the documents, or we'll talk about arresting employees here in a second. And some ICE officers, generally they know what they're doing, and if they have shown up without a search warrant or some sort of warrant or subpoena, that happens quite frequently, and they know they're showing up without it, and they know that they'll probably, if you push back against them, they'll have to go back and get it. But certainly you can encounter those ICE officers who are just not well trained. They're sort of testing the bounds of their authority. And it's kind of hard to know what to expect until you're actually in that situation. And I know that I'll sound like a broken record here, but that's why it's so important to get experienced immigration counsel on the phone, or experienced counsel or an attorney on the phone as soon as possible, just so that they can assess that situation and sort of know how to handle it. But sometimes ICE does come to arrest an employee. Sometimes they might be looking, if you're a college or university, they might be looking for a student. They might be looking for a patient if you're a hospital. And they might be targeting a certain person. If you're a worksite, they might be coming to do a worksite raid. Tony talked about worksite raids are a little bit less common now, but they're still occurring. Usually in these kinds of cases, ICE is going to present a search warrant and or an arrest warrant to arrest the person. And the best practices are generally the same. We're talking about, we want to obtain a copy of that warrant. You want to look at the exact information that's on that warrant, who's it looking for, and then bring that person to the officer. Don't let the officer go wandering around searching for that person. One, that's going to disrupt your workplace or your organization. And two, you don't want the officer snooping around where they don't belong or where they are not entitled to be. And that goes because once you allow the officer to go into sort of a workspace, you're actually consenting to that officer entering that workplace and searching it. So to the extent you should be bringing that person to the ICE officer. And then if the officer has the permission or has the ability to go onto your premises or go into a private place, make sure that you are accompanying the officer at all times. I want to make a quick note about public versus private areas because I think this is a huge concern. ICE officers can be in a public area, and I'm talking about any area that is open to the public. So it might be a restaurant dining area or a campus quad or an area of campus that's open to the public. Parking lots, lobbies, waiting areas, the public is allowed to be in there, so is an ICE officer. And they can arrest somebody in that area without a warrant or some other basis, without having a search warrant to go into a place where that might be private. Private areas of your organization, if you're a university, it might be a dormitory. If you are a work site, it might be someplace where you take a key card to get in. They need a search warrant, or they need the employer or the organization's consent to search it. You can always ask for that search warrant in those kinds of cases if they're going into a private area. If you do not want to consent, you can always consent. If you are asking for a search warrant, be sure that they will come back with that search warrant. But in those kinds of cases where you say, hey, you don't have a search warrant, I can't let you in here, and they say, okay, fine, we'll come back within. That gives you some time to at least call counsel, get your things in order before they come back. And the last tip here is just if you have areas that are private from the public that might not be so obvious that they're private, mark them as private. It may not. There is a lot of law that goes into the public-private area distinction, but certainly one thing that can help is just marking the area as private.
Okay, so ICE was our primary player in worksite enforcement, but another large player, of course, is the United States Citizenship and Immigration Service, USCIS. It is primarily a benefits granting agency, but it also has a squad of investigators for fraud. The USCIS FDNS, the Fraud Detection and National Security Directorate, is an arm of USCIS, and these people will appear at your work site, but only if you have sponsored foreign workers, because what they're looking for is fraud in the immigration benefit application process. So if you are, for instance, the employer of an H-1B employee or an L-1 employee, again, those are typically professional type people or technical people, and you have hired them from abroad, then FDNS might be interested in that. This agency was created in 2004, hasn't been around for a long time, but they assess whether the H-1B program in particular, but now the L-1 program, is being used correctly. You may have heard, because it's been on the news quite a lot lately, that Congress and the President are not happy with the H-1B program. They think that there is fraud in the program, and they're not happy with the way it, they believe that it affects the U.S. Worksite. So there is very likely to be increased attention to the FDNS function in the near future. There is an FDNS officer located in every USCIS field office, so most of you probably have never been to a USCIS field office, but if you were to go to one, you'd find one of these guys there. They partner closely with ICE, as you might guess. When they come to your work site, they may come because they have decided randomly to visit your work site, or they may have a reason. They may have a targeted visit in mind. Random site visits are just meant to be a check to be sure that an individual H-1B worker is employed in the way that the employer that petitioned for them said they were going to be. So they're in the right place, they're being paid the right amount, they're doing the kind of work that was described in the petition, they are working the hours that were reported, and so forth. They're just checking on the bona fides of that application. A targeted site visit is done when the FDNS officer has received information that the H-1B program has been violated. The officer can ask to see the public access file for the H-1B worker. For those of you who employ H-1B workers, your immigration attorney has probably provided you or at least assisted you with building a file of documents that has to be made available not only to government inspectors but also to members of the public about the employment of that H-1B worker. They may come in and talk to the H-1B worker, him or herself. They may talk to the person who signed the H-1B petition. That may be the human resources officer in some cases. And they may talk to other people. They may talk to managers and in some cases to coworkers. So the fraud people may take photos of the work site just to sort of illustrate what's going on at any particular place. They may look at pay stubs, job descriptions, other kinds of wage information just to get a sort of a mental snapshot of what's going on with that particular situation so that they can report back and decide if there is fraud in this particular case. We do have an idea, because it's been published, of what the fraud investigation policy is going to be for H-1Bs in the year 2017. There's going to be increased H-1B site visits with a focus on identifying employers who abuse the system. This is consistent with what has come across our national news. There is a strong feeling in some members of Congress that the H-1B program is not working the way it was intended. And so fraud is a piece of that, although not all of it, and there will be investigation on that. The priorities of the FDNS for this year, the employers that they'll look at first. First of all, they're going to look at employers who don't have Dun & Bradstreet information available. That seems sort of arbitrary, but because not everybody does have that information. But CIS believes that, rightly or wrongly, that a bona fide place to look about information about any given employer is Dun & Bradstreet. And if you're not there, they are suspicious. So that's going to be an employer that they're going to investigate, or they might put at the top of their list. They're also interested in H-1B dependent employers. This is a legal term because it's defined by statute. It's employers who have a high percentage of H-1B workers as compared to their other workforce. So they're going to be high on the fraud investigation list. And then employers who are petitioning for people to hire under the H-1B program and send out into other workplaces to hire out, staffing companies. IT companies are also probably going to be high on their list. So best practices in this area, the FDNS fraud investigator appears. What are we going to do? Consult with counsel who can help you decide in individual cases maybe what the concern is, how best to approach it. Before they arrive, though, there are things that you can do to put yourself in the best possible situation if they get there. Now, again, remember, these guys are only going to be in your workplace if you have sponsored foreign workers. So if you have, you're going to have a public access file for every H-1B worker. If you don't have one, you need to get that created. And they need to be maintained. There are times when things need to be changed in that file or updated. So be sure that it's maintained over time. If there are going to be any changes to the working conditions of your H-1B or your L-1 worker, job duties, worksite, substantial change in location, wages, hours worked, those kinds of things, then you probably need to at least consider whether you need to file an amended petition just to make sure that when the FDNS investigator shows up, they find the circumstances that you have described in your most recent petition. And again, the broken record, be sure you get the name and number of the investigating officer.
Well, that takes us into worksite inquiries generally, and liability for employing an unauthorized worker. I think this situation, a lot of people, a lot of organizations assume that, oh, no one's ever going to show up on site, nothing can ever happen, we do our I-9s right, and then it happens. Somebody gave you a false document, you received something in the mail, and all of a sudden you're faced with the situation where you might be, or you know you are, employing an unauthorized worker. Their employer is liable if they knowingly employ a worker who is not work authorized. This results in fines. But if you are harboring a worker who is not authorized to work and sort of concealing them from government detection, there are criminal penalties that can attach to this type of action as well. So it's really important, your I-9s, of course, are your front line, but certainly there are certain situations where you might have constructive knowledge that somebody is not work authorized, because that's the standard, whether or not you have constructive knowledge. And this is really a reasonable person standard. I mean, are you acting as a reasonable person, exercising reasonable care, and knowing that your workforce is all authorized to work? And it can trigger a duty to investigate if certain things come across your desk that indicates that a person is not authorized to work doesn't have work authorization. Just willful blindness, sort of ignoring the issue, pretending like you didn't notice it, or pretending like you didn't hear about it, or pretending like you didn't receive that letter in the mail from the government saying somebody is not authorized to work, we'll talk about that, is just not an excuse here. Even independent contractors, you are liable for contracting with somebody who you know is unauthorized to work in the United States. This happens a lot when I talk to employers about sponsoring somebody for work authorization, and and it might be that they can't sponsor that individual for work authorization, or it might be that it's just too expensive to sponsor somebody for a work authorization, so they say, oh, no big deal. We know that they're, we'll just contract with them as an independent contractor and circumvent the immigration rules. That's prohibited by law. So you cannot you can be liable if you are contracting with an independent contractor that is is not authorized to work in the United States. And most often that comes up when it's somebody who you thought you could bring on as an employee, sponsor them for work authorization, and it just turned out you couldn't. But of course, the I-9 process, just to reiterate, that is only done for employees. So in a couple of cases, you might have received a Social Security Administration no-match letter. This is pretty common. You just receive a letter in the mail, and it says, and it's usually a response to an employee wage report, and it says, hey, so-and-so, their Social Security number and their name doesn't match our records. And then usually they ask for some action by the employer or employee. Usually the employee. It says, please ask the employee, please hand this to the employee and tell them to reconcile this issue with the Social Security Administration. It might give them a timeline. Just similar to what you see if you're an E-Verify employer and you get a tentative non-confirmation result, sort of like that, but a little bit different in that any employer can receive one. But this letter in and of itself doesn't justify immediate adverse employment action. It could just be because you didn't report a name change, or there was reporting errors or typos in the Social Security number. Maybe the hyphenation was off on the last name, a couple of last names, or didn't include all the multiple last names. There are a number of reasons that you could receive this letter where the person is perfectly authorized to work. It was just a typo or some sort of recording error. But in some cases, it could be that it is identity theft or fraud. And in this letter actually, by receipt of this letter, it does impose obligations on you as the employer to at least investigate or at least follow the steps on the letter itself, or talk to the employee about the letter. But you should not ignore it. Again, willful ignorance is just not an excuse here. But you should also not assume that the employee is not work authorized. Again, it could be a typo. And so you don't want to take that adverse employment action. You don't want to terminate them without more information. So read those instructions on the letter, confirm that a valid I-9 exists for that employee, that you went through that process and determined that this employee was work authorized, and then give the employee a reasonable amount of time to resolve the issue. Usually it'll amount to they need to go to the Social Security Administration and fix something. And honestly, in most cases where you have an employee who's truly unauthorized to work, as soon as you hand them this letter or you confront them about it, they will not show up the next day. In most cases, they just won't come back. So you need to give the employer a reasonable amount of time to resolve the issue. What's a reasonable amount of time? 2 weeks is probably too short. It's the government. They take a long time. So a year is probably too long, but reasonable amount of time. If they keep pushing it off and they just haven't done it, or they keep telling you that, oh, it's in process, and a year later you still haven't heard something, that might raise some red flags there at that point in time. All right, how about a poll question to break things up a little bit before we get into this last chunk of material? Has your organization ever received a notice from a state agency? So, a state agency, either Missouri government, Kansas government, or another state, requesting specific forms I-9. I ask this because this seems to be coming up a little bit more often, and we saw a lot in Colorado at one point when they had a specific law that's no longer in existence asking for I-9s, but certainly it's happened. But it looks like only very few of you have actually received one, and many of you probably don't know or may not have be in a position to know, but we do want to talk about it because it does happen. The state agency notice, they can come in and they usually ask for information about a certain employee, and the best thing to do is just to read that notice carefully and look at the exact information requested. One thing we wanted to highlight here is that there's a federal law that precludes the release of the form if your Form I-9s to a state agency. In fact, the Forms I-9 are sort of have some privacy protections around them, in that you are, as the employer, are only allowed to release them in certain situations, and usually they're federal government investigations. So state agencies not permitted to give up the Form I-9 in those situations. But these types of notices where the state is telling you that the employee is unauthorized to work might trigger a duty to investigate. So maybe at this point you need to sit down with the employee and ask them, hey, I've got this notice in the mail, can you explain this discrepancy, just depending on the situation. But in any kind of notice like this, the first thing to do is contact an experienced immigration attorney. You know, that's on every single best practice list we're giving to you today, and we cannot emphasize that enough, especially because these state agency notices can be a little bit tricky. Be aware of state immigration laws. You know, even more generally, state immigration laws are changing all the time. There are certain states that requiring release of information, and so be aware of what those immigration laws are. You know, even E-Verify laws now, a lot of states are mandating E-Verify or E-Verify for certain employers. And then you can always contact a state agency as soon as you receive that letter, and we would suggest that you do, to determine the purpose of the request. So, you know, before you do anything, you might contact them saying, hey, I got this in the mail. Can I ask what this is about? Just to get a little bit more information. The last thing in this particular section that I want to highlight is INA 287G, which that section probably means nothing to you unless you are an immigration law junkie like the rest of us and have read the executive orders and Department of Homeland Security memos. But this is a provision of the Immigration and Nationality Act, which authorizes the Department of Homeland Security, ICE, to deputize local law enforcement agencies to enforce federal immigration laws. So essentially, this is, the idea is Department of Homeland Security, or ICE, would enter in an agreement with a local law enforcement agency, and they develop this program to train local officers to identify and deport undocumented individuals. So essentially getting the police, local police, to do the job of ICE, because ICE doesn't have enough, may not have enough resources, or, you know, establish some sort of partnership with local officers. The reason we bring this up is because, and usually this involves, you know, police officers who are out in the streets pulling over people or enforcing, you know, state and local laws. But the 2017 executive order by this administration has requested an expanded use of this 287G program to implement more programs and partnerships. You know, and ideally, you know, for them, they're thinking at the border, but this also has been expanded to even communities throughout the United States, which just means that for you as an employer or as a representative for your organization, you might see local law enforcement now involved in these worksite investigations, or now showing up at your organization to enforce immigration laws where it used to be an ICE officer. So it's just something to be aware of. It sort of remains to be seen. In this last portion, we want to talk about preventing a worksite enforcement action. So what are your obligations as an employer? We're going to talk about several situations, and I have a list of questions on here. And when we split up the slides, I thought, oh, okay, I got the sections that I wanted, and then I realized that I had the one with all of these tricky situations when you receive a workplace tip. Because there's some gray area here about what you need to do in certain situations. So we wanted to spend our final moments here, you know, really talking through some of these situations that can happen and how to address them when they do happen. So sometimes you will hear have a rumor circulating around that a certain employee is undocumented. Or you might hear, you know, somebody told somebody that their coworker is undocumented. In those kinds of situations, that doesn't really give you constructive knowledge. This is just a rumor, or it's hearsay, and you don't really know that this person is undocumented. And you know, when Tony and I were talking about this earlier, we talked about how you really need to kind of understand, like, what is the motivation? Do they just not like this person? Are they coming in as a group because they're sort of ganging up on another person in the workplace? So in part, you know, remember that your standard is constructive knowledge, and as a reasonable person would act in this, exercising reasonable care. So if this is not raising any, red flags, and it's just, okay, thanks for the tip. I understand that you have heard that this person is undocumented. There's really no obligation, and in fact, no need to follow up in those kinds of situations. But you might have a situation where a manager overhears an employee talking about his unauthorized status. And in this situation, it's more direct knowledge. Or you might have a manager who comes to you and says, I know this person is undocumented. In those kinds of situations, that might be when your red flag is sort of raised in your brain. Maybe we need to look at this situation a little bit more intensely here. And this is just because now you have to think about, again, the motivations. Is the manager telling you because they're concerned about the company's liability here, or is there some ulterior motive here? But usually if they are coming to you and they have direct knowledge that this employee is unauthorized to work, at that point, it's time to sort of investigate a little bit. And that might mean pulling that person's I-9 and making sure you went through that process with that person. If it raises to a certain level, maybe you need to bring that person in to talk about them, to say, hey, we had a manager here. They said that you were bragging about your unauthorized status and how you got through with fake documents so easily. I'm telling you that I've heard this, and confront the person that way. But again, you're a reasonable person exercising reasonable care in these kinds of situations. And the best thing to do is, again, contact experienced immigration counsel who can sort of walk the fine line between, are you going to get liability for discrimination for singling an employee out, or is this really a situation where you really need to look into it? You have that duty to investigate a little bit further. Sometimes you might have a situation where you have employing multiple family members, and three out of the four are discovered to be undocumented, or maybe they get deported. In those kinds of situations, you can't assume that the employee is undocumented. A lot of times you have a family that one person is documented and the rest are not. So those situations happen, but it does not necessarily mean that you're the one sole employee who wasn't investigated or wasn't deported is not work authorized. Sometimes you might have an employee who asks for work authorization sponsorship. And this, again, in and of itself, without more information, does not necessarily trigger a duty to investigate either, unless you start going down the line and that employee tells you, no, I need a work authorization sponsorship to work for you at all. And in those kinds of situations, of course, now that they have directly told you that they need work authorization sponsorship. But certainly you can have those employees who might have work authorization for the next 2 years, but after that will require sponsorship. Another situation that comes up quite frequently is when you have a trusted manager admit that he has been helping an unauthorized employee, meaning that trusted manager sort of felt sorry for the employees. Maybe they sort of sympathized with their situation, and they said, I know that this person doesn't have work authorization, but they're just such a good worker, and I'm going to have a hard time replacing them, and I need them, and they just conceal them. Well, this is a situation where you really need, where you definitely have constructive knowledge that this person is unauthorized to work, and you need to take additional steps. It probably means bringing in that employee, checking their I-9 to see if they got through the I-9 process, talking to that employee, and again, now you have a manager who is violating immigration laws as well, which can create other problems too.
And anytime a manager has actual knowledge of an unauthorized worker in the workplace, he's acting on behalf of the company, so the company is liable, even if nobody knows it but him.
One situation I didn't have on this slide was where an employee comes up to you, and this is actually on the next slide, but you have an employee who comes up to you and presents a new Social Security number.
That's one of our questions, actually.
Okay. Well, look, I'm ahead of the game. But an employee filled out an I-9 with one Social Security number, and then all of a sudden they come up to you and give you a new Social Security number and say, hey, this is my new card. I wanted to give it to you. And it's completely different from their I-9. And this situation's kind of tough too. Maybe they made a mistake on their I-9, but in most cases, it probably means they weren't work authorized. It might mean that they weren't work authorized and now they are. And that can be a tricky situation. One best practice here for all organizations is to have an honesty policy. If you don't have one, makes it a lot easier to say, well, it looks like you weren't honest with me to begin with. We have an honesty policy. This is a violation, and now I'm going to terminate your employment. Having that just blanket policy is always the best practice in these kinds of situations.
Assuming, of course, that it's uniformly enforced.
Exactly. Needs to be uniformly enforced throughout your organization and not just implemented just for this individual.
Sometimes an employer doesn't really want to discharge a person who has a new Social Security number. Sometimes this is a long-time, valuable employee who's become friends with everybody in the place, and so the question becomes, do I have to fire that person? What do I do if I really don't want to?
No, you can just edit the I-9 and correct the I-9 with the new Social Security number and accept their new documents and keep them employed at that point in time.
With the idea, of course, that if you are audited by ICE in the future and they find out that you went through this exercise with this person, it won't have any adverse effects per se, but they may look a little more carefully at your records. They may be a little more skeptical about the credit that you may have given to one or more other employees. So just be aware that while you're permitted to do that, it may have sort of psychological effects on any kind of encounter that you may have with ICE in the future. And if that employee actually isn't telling you the truth about his or her new Social Security number and he or she is still not authorized, then that's a real problem if ICE catches on to that.
Exactly. There are certain situations where you really need to make sure that you are inquiring and doing a little bit of investigation. You don't have to be the FBI here, but you do need to be exercising some reasonable care to ensure that that employee is authorized to work. Certain situations include an E-Verify non-confirmation result. If you're an E-Verify, E-Verify makes it pretty easy. They tell you exactly the steps that you need to take as the employer, and they usually give you some time limits on those steps. Sometimes an I-9 audit will reveal that an employee did not present the appropriate documents, and in those cases you're on notice that that employee might not be authorized to work, and you need to go back to that employee and have them recomplete the I-9 or present appropriate documents because they didn't do so in the first place. It might be that you have an employee who admits to not being work authorized, and that's kind of similar to the employee presenting a new Social Security number. If they are no longer authorized, if they admit that they're not being work authorized, then you're not authorized to employ them at that point in time unless they do have new documents at that they can bring you to show that they are work authorized now, but they weren't before. Any kind of notice that you're getting from a state or federal agency, make sure to read those carefully because if you're finding out from a state or federal agency that you have individuals who are not authorized to work, you should make sure that you are following the instructions on those notices, contacting immigration counsel or experienced counsel in those situations, and sort of taking some steps to ensure that your employees work authorized if they say that they're not. Certainly you can take ICE at their word. If they send you a notice to say, hey, this person isn't work authorized, you can take them at their word that that person is not work authorized. Sometimes you get a notice from an insurance company or some sort of benefits organization that an employee's Social Security number is assigned to somebody else. They'll say, hey, so-and-so applied for benefits, and it looks like, our records indicate that they're employed by your organization, but it looks like they're not. And those notices come up quite frequently, and it can be kind of confusing on how to handle them. But really, that is putting you on notice that you might have an employee who is not authorized to work and you need to inquire a little bit further. Usually this means talking to that employee, bringing them in, confronting them about the notice that you received and asking them to explain it.
Sometimes in an I-9 audit, the officer, the investigator will ask you if you've ever received any of these kinds of notices. The Social Security no-match letter is the most common one that they may ask for, but occasionally they'll just ask you more generally, have you ever gotten any kind of correspondence indicating that some of your employees are not authorized to work. So this could actually become a very, very obviously problematic issue.
Well, that was a lot of information in an hour, and unfortunately we know that there are a lot of questions and we weren't able to get to them all as we were going through. And we were only able to sort of skim the top of these topics. But we encourage you, if you do have suggestions for future topics, if you'd like us to take a deeper dive into any of the topics we talked about today, let us know. If you are an institution of higher education, a college or university, we are doing a higher education webinar on September 26th on it is mostly on ICE enforcement and other enforcement actions related to students, so new immigration policies related to international students at organizations. So if you have questions about that, be looking for that invite. It'll probably be sent out next week.
Well, thank you for joining us for our program today. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit, and for HRCI and SHRM recertification credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. This concludes our webinar. Thank you.